Good morning and welcome to the fifth meeting of the Equalities and Human Rights Committee for 2020. Can I ask that all mobile devices are switched off or on silent, please? Agenda item 1 is an oral evidence session on the Civil Partnerships Scotland Bill at stage 1. Can I welcome Cabinet Secretary for Social Security and Older People, Shirley-Ann Somerville, Simon Stockwell, Family Law Unit Head, Sarah Meanley, Family Law Unit, and John Thompson, Solicitor from the Scottish Government. You're all very welcome this morning. Thanks for being with us. Can I just start by saying that we're limited to an hour this morning and we have lots of questions to get through. So the committee are going to be very disciplined and concise in their questioning, and answers like that as well would be much appreciated so we can get through everything. And with that in mind, I'll go straight to Alison Harris.
I would like to ask, can you explain to me the legal differences between marriage and civil partnership?
Certainly, I mean, there are some legal differences between marriage and civil partnership. Obviously, what we've tried to do within our bill is to ensure that this reflects what happens really for same-sex civil partnerships. So there are some differences on that, not a huge number. I suppose you can really break them down to 3 sections. What happens in the creation of the relationship, what happens during the relationship, and what should happen if couples decide to end the relationship. So on the first strand, the committee has obviously heard that there are some differences in the number of religious and belief bodies that are authorised for the purposes of the solemnisation of marriages and registration of civil partnerships, and that reflects the views of the bodies themselves. On the second strand, there's a difference in relation to survivor benefits and pensions. And finally, the third strand, when it comes to ending relationships, is that there are some areas featuring in the law on ending civil partnerships that don't exist for civil partnerships but do exist for marriages. So those are the kind of, I suppose, quite a simple breakdown. I hope that gives enough information.
I think that does, thank you. There are currently no plans for a campaign to explain what it will mean when civil partnerships are extended to different sex couples. But the Association of Registrars said that the guidance on the difference between marriage and civil partnerships would be helpful to inform the public. So could I ask you, what are your thoughts on providing some guidance?
Well, I think that's something that I was very interested in seeing as part of the evidence that's going forward. I mean, this is very much a personal decision for people when they're moving into a relationship. If they want to move that forward, it's really much a choice for them. It would obviously therefore assist if they had an understanding about what the differences were between the rights that they may have, for example. So I think that's a very interesting area which obviously we'll give further consideration to, with the full mind that it really is obviously very much up to the couples themselves to decide what's right for them.
Thank you, appreciate that. Several witnesses have suggested that adultery as a ground of irretrievable breakdown is outdated and could instead be covered by the grounds of unreasonable behaviour, which can be used for a range of infidelities. Is that something that the Scottish Government would be considering for reform?
Well, I think that would be very much part of divorce law, and not something that's for this bill. So I can appreciate why people are saying that these aspects are outdated. It is reasonable to see that it's not something that's widely used at all, but that would be something for consideration in a different bill rather than this one, I think.
Thank you. I think your answers have been helpful.
Okay, Mary Fay.
Thank you, Convener, and good morning. I wonder if you could give the committee a bit of detail about what you think the impact of the introduction of different sex civil partnerships will have on the different equality groups.
Well, it's an interesting area which I know, again, you've received evidence on. I think it will have a positive impact on a number of equality groups. I mean, obviously, there's the extension of civil partnerships itself will provide heterosexual couples with the same option for legally recognised relationships as is currently available for same-sex couples. And I think that levelling up of rights is an important area that we are looking to achieve as part of this bill. There's obviously people in same-sex civil partnerships that will no longer be concerned, for example, about being outed if people are talking about being in a civil partnership. And I think, again, that's maybe something that is certainly advantageous. I believe, obviously, you heard last week from the Young Women's Movement that the bill could also through increased access to the rights that flow from a legally recognised relationship help support women, which was I think an interesting take on that as well. So I think there are a number of areas where this could benefit people that actually aren't themselves going to be taking part in the mixed sex partnerships themselves.
One of the most frequent answers we get when we ask what are the benefits of different sex civil partnerships is the financial security that this kind of formalised arrangement will bring, that currently married couples have, but civil partnerships don't have. Are there any other benefits apart from the financial aspect that will come with this legislation?
Well, I think that you're absolutely right to say that there are financial benefits that could come from this. It may be the case, for example, at this point in time that a couple do not, for personal reasons, wish to move to a marriage and are therefore in a cohabitation relationship, that there obviously has a difference in the rights that they have from obviously cohabitation to marriage. What they now have, if this bill is successful in becoming an act, is another alternative where they can have a legally recognised relationship that brings with it some of the financial benefits you've talked about. I think the importance as well of giving people choice is very important. I've listened very carefully to the evidence you've had, and obviously within our consultation, where people have spoken very passionately about why they feel that marriage is not right for them. And I think there is an obligation on government to therefore see what can be done to ensure that they can be in a legally recognised relationship, have the benefits that flow from that, and have something that fits their personal beliefs and the way that they want to live their life. So I don't think, while the financial implications are obviously important, I don't think we should underestimate the importance of allowing a couple to be able to be in the type of relationship that they want to be in and have that legally recognised is very important.
So you would see improving choice that's available to people is a very important factor in this?
I do, and I think, as I said earlier, it's about that levelling up of rights. So if we have the rights for same-sex civil partnerships and same-sex marriage, clearly the question quite rightly is, well, why shouldn't that same choice be available to other couples? And that was why when we looked at the second consultation on this, we obviously looked at one option could be to end civil partnerships for everybody, or to increase the civil partnerships to make them available for all. That levelling up of rights, I think, is very, very important. It gives that choice to people.
Thank you. Thank you.
The bill replicates existing provisions with regard to how religious and belief bodies might want to opt in to register different sex civil partnerships. We have taken evidence that the bill might need to be amended to take account of additional checks on Jewish clergy that may not be represented by different branches of Judaism in Scotland. Just wondering what your views are on this specific suggestion.
Yes, depending on how much detail you want to go into, I may bring Simon Stockwell in on this as well. But we've listened very carefully to the evidence that's going on, and officials have also taken further meetings forward to ensure that we get this right for everyone. So I don't think that there are drafting changes that are required. I know in the overall oral evidence that was given that there was issues raised, and we've looked very, very carefully at whether any drafting changes are required. I think we need to be very careful as a government not to interfere in the internal workings of a religious body, and absolutely to respect where there's a role for government and where there's not a role for government. If anything further comes up that would suggest changes are required in that, then I would be more than happy to look at that. I don't think they're required at this time, however. But I don't know if you'd like more information on that. We can go into the very specific details of that if you'd like.
I think that's sufficient. Thank you.
Okay, Angela Constance.
Good morning, Cabinet Secretary. If the bill's passed, when would you anticipate the introduction of civil partnership registration for different sex couples?
Well, I know evidence has been given to committee on the timetable for this, and people are obviously keen that we move ahead as quickly as possible. Once the if the bill is passed by Parliament and becomes an act, there are other areas that we need to look into. So, for example, we need a Section 104 order at Westminster. We need a number of SSIs to go through this Parliament, changes to forms and guidance, IT changes and training and so on. We would therefore expect the first mixed-sex civil partnerships to take place in Scotland in early 2021.
Okay. And you mentioned the Section 104 order. I wonder if, just for the record, if you could say why that's necessary and what it will contain, roughly.
Sure. Well, in general, this order will amend existing legislation to reflect the introduction of the mixed-sex civil partnerships, and we're discussing, obviously, the details of that with the UK government. So at the moment, our thinking is that it will have to include amendments to the Equality Act 2010 to provide protection for religious and belief bodies that do not wish to be involved in the registration of mixed-sex civil partnerships, changes to the Human Fertilisation and Embryology Act 2008, and provisions in relation to consular and armed forces civil partnerships overseas where the couple identify with Scotland as a relevant part of the UK.
And as a matter of interest, I wonder why the government opted to use primary legislation as opposed to secondary legislation. I'm conscious that Westminster were able to quickly respond to the court judgment via regulations.
Yeah, well, this was because it was initially dealt with through a private member's bill in Westminster, which then gave the UK government the power to move forward through regulations. Because we weren't Scotland wasn't part of that private member's bill, it's therefore impossible for us to move forward in regulations as has been done in the UK. We did look at other options to see whether there was a way to speed up the process here. So one of the examples was the consideration of a human rights remedial order. On reflection, when we looked at that, I really didn't think that that would include everything that was needed to establish mixed-sex civil partnerships in Scotland, because they are very narrowly framed, orders are very narrowly framed. And actually, when we looked at the timetable of achieving an order compared to achieving a primary legislation, there actually really wasn't that much difference either in the timetable. So given that lack of given the fact that we weren't part of the primary legislation down in Westminster, given the fact that the human rights remedial order really wasn't a good fit for this and actually didn't save us any time really, then the primary legislation route is the only route we can go down.
Okay, thank you. That's convenient.
Let's go, Hamilton.
Thank you very much, Convener. Good morning, Cabinet Secretary, and good morning, Simon Stockwell. Thank you for coming to see us today. We have heard quite a bit of evidence over the course of stage one about the importance of this law in respect of the views that people have about marriage, and that marriage has obviously a lot of baggage attached to it and actually can become quite an emotive topic for some people. That is why there is some anxiety around the interim measures before this act fully commences, in as much as civil partnerships of different sexes registered outside of Scotland will be regarded as marriages should they either visit Scotland or move to Scotland for the interim period. What do you think we could do through this act? I mean, could we approach this differently? Could we, for example, instead of regarding them as marriages, regard them as civil partnerships until the act is commenced?
No, and I do appreciate, again, evidence was given very strongly on this area. And I think that the aspect I would like to stress about this is that the interim scheme of recognition is at its heart about the access to rights. Obviously, if a couple come to Scotland, come and stay in Scotland, they can still say they're in a civil partnership. They can still use that terminology. It's absolutely not to say that they must change and therefore talk about the fact that they're married. This is about the rights that they would have when they're in Scotland. So the options really are, we could have no interim recognition at all. And therefore, if people were to move up to Scotland in a civil partnership, a mixed-sex civil partnership, then their rights wouldn't be recognised whatsoever. We can, as we've suggested, have the area where they are deemed about access to rights as being treated the same as a married couple. I did note that there were some suggestions within evidence sessions you've had that we could somehow act as if they are in a civil partnership, and there's been some suggestions to some technical changes that could be done to this bill to allow that to happen. I'm afraid I don't see that that could actually work in reality, because unless we have all the secondary legislation that goes alongside this primary legislation, we don't actually have a comprehensive body of law that would allow us to actually be able to say that they had the rights of civil partnerships. So there would therefore be a risk of people missing out on rights because we don't have that comprehensive body. So this is something which I absolutely appreciate. If people are wanting to go into a civil partnership and not marriage, they will obviously then not find it ideal whatsoever that we are saying that they should be classed as a married couple. But I would go back to that original point that I made. This is about their access to rights rather than what they would call themselves within a partnership. And I hope that gives a little bit of reassurance, and a reassurance that we've obviously also looked at the other alternative options, and I don't feel that that would give the access to rights that I think couples would expect and would hope to have.
Thank you for that. I find your arguments very compelling. Nevertheless, that anxiety still exists, and I wonder if perhaps we could, the Cabinet Secretary would agree to meet with me, perhaps to discuss potential drafting change to the language around that section, which, whilst it recognises that this may be the only way to deal with it, that we can change the language or soften the language. So, in as much as rather than saying, I can't remember, I don't have the bill in front of me, but I think it's like will be treated as a marriage, that we could say that mixed-sex civil partnerships who relocate to Scotland will enjoy the same rights as married couples, or something like that, which softens the language. Perhaps we can take that.
Absolutely, be more than happy to meet with you to discuss that. I really do see the point and the challenge that we have in this area. If there's other avenues that can be looked at in terms of drafting that allows that access to rights, we'd be more than happy to look at that.
And final supplementary on this point before I move on to my other question, is that another suggestion that was made to us, I think by Tim Hopkins of the Equality Network, is that actually the best way to deal with this is just to do it quickly and to commence as fast as possible. Is there any way that we can truncate the commencement period?
No, because unfortunately it doesn't all rest within our hands. So yes, the bill can proceed through this Parliament as quickly as possible. That would obviously be fantastic. But as I've said, there's work that still needs to be done, not just within this Parliament, but including Westminster as well. And the drafting between the Scottish and Westminster governments will need to run its due course, and that doesn't lie within our power. I'm more than happy to look at what can be expedited, but I really don't see, because of that requirement for that comprehensive package of law, both within secondary legislation and the Section 104, that it can be delivered quickly. But we are determined to move as fast as we can on this within our gift.
Thank you very much. The other area I would like to ask is about the possible need to re-register children on the commencement of a civil partnership. The Births and Deaths Registration Act of 1953 and the Legitimacy Act of 1976 require that children are re-registered who are children of either cohabiting parents who become married or in this case in a civil partnership. Now I understand that European Court of Human Rights judgment in 1979 of Mark v Belgium kind of renders that unnecessary, but it still is a confusion, I think, for registrars. Can you confirm whether children will need to be re-registered on the solemnisation of a civil partnership, or whether we need something in the bill that specifies that this isn't an issue anymore?
So there are very detailed arrangements in England and Wales on birth registration, and they're very different to what happens in Scotland. So I appreciate that that's an area of concern. It's not an area that we feel needs to be of a concern in Scotland. It's a different relationship up here on birth registration.
Mary Fee.
Thank you, Convener. I wanted to cover the issue of interim gender recognition, and you'll know from, or you'll be aware from following the evidence, that Professor Norrie expressed concerns that the provisions in this piece of legislation were overly complex and made something more complex than it perhaps needed to be because of the way it had almost lifted and laid something from another piece of legislation. And Tim Hopkins, when he came to give us evidence last week, was very, very helpful and laid out quite clearly what his views were on the complexity of this particular aspect to this piece of legislation. And while he agreed that the provisions were overly complex, he gave us quite a detailed response of how he thought those overly complex details could be simplified and the changes that would need to be made, not to this piece of legislation, but to the Gender Reform Act and the removal of certain sections from that piece of legislation. Is that a view that you share, and is it something that you will look at as you take the other piece of legislation forward?
Well, obviously, committee will be aware that there is separate consultation currently still open around gender recognition, and there is the draft bill contained within that which suggests what we would suggest for interim gender recognition certificates. When it comes to this bill, I certainly feel the importance is to keep this bill as simple as possible. Now, that may be by putting a complex piece of another piece of legislation in and replicating that, but I don't feel that this is the place to then have a discussion about what an interim gender recognition certificate should be. So the importance within this bill is to ensure that we are replicating the current system and moving that forward, so that is within this bill as well. Any changes to interim gender recognition certificates would be part of the consultation, obviously, that's ongoing for gender recognition and would be taken forward as that bill. And I'm very keen to keep the two areas separate.
But as you take forward that consultation on the other piece of legislation, if there are any changes that are made to that proposed piece of legislation, will that have any impact on what is currently in this piece of legislation? Because you need to make sure that there's almost a kind of match between the two.
Yes, and that's what we've attempted to do here, is have the match between the two about what's within the current legislation for gender recognition and what we're proposing here. So yes, if there was then a change in the future about what would happen in gender recognition interim certificates, then that would obviously change what's in this bill as well. So I'm absolutely determined to have, in effect, a level playing field, so there is one area of law on interim gender recognition certificates, and that would be applicable regardless of the whether it came forward initially in this bill or as an amendment to the 2004
So as
Act.
it goes forward, they will be separate but the same?
Yes.
Okay, that's helpful, thank you.
Cabinet Secretary, I'd like to ask you about conversions of marriage to civil partnerships. The committee's heard that there is support for allowing mixed-sex couples to convert their marriage to a civil partnerships without a time limit on that option. Can I ask why the government's chosen not to allow for that?
Well, I do appreciate that that's an area where people are asking government to look at that as we go forward, and I'm very interested on the evidence that we've had on that aspect. The area which I'm really keen to ensure that we get is I suppose as wide a breadth of thoughts on this as possible. I do appreciate that people think that it should be in here. The reason that we've developed the bill as we have is because we are really looking to link different sex civil partnerships with the rights that are available for same-sex civil partnerships, and that is an aspect which isn't available currently for a same-sex marriage to change to a same-sex civil partnership. So we would be asking in effect for a right to be available for people in a different sexed marriage to transfer to a different sex civil partnership. if you're following with me, if I'm making myself
Just about.
clear. So the challenge really as we go forward is how you move in an area which is different, because I suppose in same-sex relationships we moved from just same-sex civil partnerships being available, and then same-sex marriages came on board. And in this area of law, we're moving where there's different sex marriages being available, and then there's different sex civil partnerships coming along. So I appreciate there may be some people that are in a marriage that did that because they wanted to be in a legally recognised relationship, and the only option to them at that point was marriage. Therefore, I am interested in what's being discussed in committee around this. And it's an area which I'd be happy to consider. There are difficulties and challenges in that. For example, how if someone has been in a marriage and they move to a civil partnership, then how we treat those civil partnerships when those civil partnerships come to an end, because they may have been married longer than civil partnerships have been available. So this is not a simple process. There are some legal challenges around how that would be dealt with. But it is an area, as I say, I do appreciate that you've had evidence on. I do appreciate that there are views on this. But I think it's very challenging to see how that can be done without recognising the implications and the challenges that come with that.
There are proposals to allow different sex married couples in England and Wales to convert their marriage to a civil partnership. What would the implications be if it went ahead there and not here in Scotland? Do you know?
Well, that's entirely up to Westminster to take that forward. It's not something that's currently available as an option, as the regulations have passed, and it may be something that they will indeed look at. The important aspect for Scotland is how we would treat those people once they moved to Scotland. And therefore, if they're in a marriage, then they're treated as if they're in a marriage. If they're in a civil partnership, once our civil partnerships are in place, then they would be treated as a civil partnership. But again, we just need to bear in mind the complications of what happens, for example, at the end of a civil partnership, and what rights are available for people at that time.
I suppose what draws to mind is some of the evidence and discussion we've had has been around, you spoke about levelling up rights and, you know, sort of equality of choice and things for people. And if we got to a place where you had that choice in other parts of the UK but not here, could that mean that you were kind of forced to do it at a later date rather than taking care of it in this bill?
I mean, no, there are areas, particularly in family law, which are different between England and Scotland at the moment, whether it's on cohabitation or other areas of family law. So there are differences in how we treat these aspects between England and Scotland.
Though that people have more rights cohabiting in Scotland than they do elsewhere, not less. Whereas if this goes ahead, you'd have less of a choice, not more.
You do, and that's why, as I say, I've been very interested in the evidence that's came forward on this aspect. I think perhaps what it hasn't looked at today are the challenges that we would have to ensure are looked at from a legal perspective around how we would deal with I guess say the example I give is of the ending of a relationship. So there are challenges to it. It's not just whether it's a good thing to do or not. It would have to be very much looked at in law about how you would deal with those challenges.
To expand a bit, what in practical terms those legal sort of challenges or complications might mean for people.
Yeah, I mean, as I say, the example we've got is around, in the case of a mixed-sex marriage changed into a civil partnership, there's a question about how to treat such civil partnerships if the original marriage predated the existence of civil partnership law in Scotland. So that's one of the areas that we would need to be mindful of. I don't know if Simon's got other examples to hand as well as the one that I have.
That's the one in particular that we'd be concerned about. We mentioned that in the policy memorandum. I'm just looking at paragraph 147. The UK government themselves have also mentioned in one of their consultations that there could be issues in relation to inheritable state pension rights. And again, we've mentioned that in 146, and the UK government said they would issue some guidance in that area. And I think possibly the other point to make is that when it comes to conversion south of the border, the UK government were talking about having time limits on conversion south of the border, whereas that's not something we're planning in Scotland for changing civil partnerships to marriages. We're not planning any time limits here.
And I suppose just to press you a little on it, any thought gone into the solutions to these challenges? Because challenges are never insurmountable. I know they can be annoying, but
So with careful legal drafting, they can possibly be insurmountable. They can possibly be dealt with. I think the area is about whether there's a strong enough wish for people to have this or not. And that's why, as I say, I'm absolutely not coming here saying that the government is absolutely dead set against it, that we don't think it's possible, that we don't think it's credible for that aspect. I've listened very carefully to the evidence that's came so far. It would be interesting also to know the thoughts of religious bodies about how they would feel about being able to convert a marriage to a civil partnership, and I don't think that's something so far that's came out in evidence. It didn't come out in our consultation because this wasn't something that we proposed to do, but it may be something which would generate some discussion as well on those aspects. So these areas are, as I say, not insurmountable. You're quite right, convener, and I'm really keen and open to see the committee's recommendations in this area.
thank you, that's really helpful. Fulton.
Thanks, Convener. Good morning, Cabinet Secretary and your team. I wanted to ask about the number of different sex civil partnerships that there might be. Now, I know that the government are saying that there will be a number of about 100 to 150 a year, but the committee's actually heard various figures you might be aware of from the evidence sessions, right up to 8,000. And last week, the Equality Network told us that they feel that the figure will be somewhere in the middle of those projections. Can I ask how the government came to estimate the number of around 109?
Yeah, I think I've been surprised by some of the figures that have been mentioned in committee about the number that would come forward. The number, as you quite rightly say, that we've set out in the financial memorandum is around 100 mixed-sex civil partnerships every year. In essence, we based the calculations on information from New Zealand. So in New Zealand, marriage and civil partnerships are both open to mixed-sex and same-sex couples, and the two relationships offer very similar rights and responsibilities. So it's a comparable situation to Scotland, or as best as can be in this. So the take-up of civil partnership has been low in New Zealand, and the similarities with Scotland would suggest that it may therefore also be low here in Scotland. Now, these are difficult estimates to come up with, but as I say, hopefully the background that we've given as to how that's been done with the example of New Zealand and the fact that we think that reasonably closely replicates the situation in terms of rights about what happens in Scotland, hopefully gives the committee some reassurance about why the number is as low as it is in the financial memorandum compared to some of the other numbers that have been given in committee.
And do you think that there'll be an initial spike if and when the bill's passed, and then it'll sort of tailor off, or do you actually think it could be something that could become more popular over time and actually gradually increase? Has there been any thought given to that?
I mean, it really is very difficult to tell when something like this is brought forward. There, I'm sure there are couples within Scotland that haven't moved to unmanaged because for their own personal beliefs they don't feel that that's something that they want to do, but they would like to be in a legally recognised relationship. And once this option is open to them, those couples may wish to move forward with that. You're quite right to say that it might not just be an initial spike, it might be something that becomes more popular over time. As I said in my original answer, it really is one of those areas that's exceptionally difficult to forecast around behavioural change once we move forward with this. I still don't think it's to the extent of some of the numbers that have been referred to in committee. Only time will tell on this, but it really, in terms of what we see going forward, I still hold to the fact that the numbers that we've produced in the financial memorandum are a reasonable estimate about initial demand.
And I hear your point on that, but in the case that there was to be more, and the Equality Network, for example's estimations are more accurate than the government's, and I'm saying that, hearing what you're saying about, and I also tend to agree with what you've put forward, but in the event that the estimations are a lot higher, has there been any thought given to what the cost implications could be in the systems that are in place? Would they be able to cope with that?
Well, absolutely, the systems would be able to cope with that. I don't see this as something that's going to dramatically change overnight that can't be foreseen. I mean, I think this is something that will develop over time, but it's a robust system that we have here in Scotland, and if there's obviously movements that are seen on this, then they would be catered for. We may get the fact that people aren't legally registering in terms of a marriage, but are legally registered in terms of moving into a civil partnership. So therefore, what we're doing is therefore seeing a change in the type of legally recognised relationship that people are moving into, rather than an actual overall increase in demand in the numbers.
Okay, thank you. Can I ask a follow-up question about cohabitation as well, Convener? I wanted to ask a final question, Cabinet Secretary, just on the, if you could explain the difference between the rights of cohabitants and the rights of civil partners in Scotland, and if there's any plans from the government for cohabitants to have stronger rights and responsibilities.
So cohabitants have some rights, but they're not as comprehensive as the rights that are available and extended to spouses or civil partnerships. There are differences, for example, in parental responsibilities and rights, succession, pensions and occupancy rights. As I think the committee has heard already, the Scottish Law Commission are carrying out a project on financial provision for cohabitants who separate, and that discussion paper was published in February. So cohabitants do have rights, and as a member has pointed out earlier on, they have more rights here than in England and Wales, but there are still differences obviously between what's available in terms of rights if you're cohabiting in Scotland compared to a legally recognised relationship. But some of those aspects will obviously be dealt with as part of the Scottish Law Commission discussion paper.
Okay. Are committee content? Everyone else? Okay. Thank you very much for your evidence this morning, Cabinet Secretary. The next meeting of the committee will take place on Thursday the 12th of March, where we will be considering petition PE 1695 on access to justice in Scotland, and we'll also be looking at our approach to the inquiry on race equality, employment and skills. And we now move into private session.